Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello, welcome to podcast 75, 3/4 of the way to a century now. Well, in this podcast we're going to be discussing three different cases. The first one, it looks at the impact on an employee's dismissal of an employer's failure to follow the ACAS code, amongst other procedural flaws during the disciplinary procedure. Secondly, we're going to look at a permanent anonymity order made by the Tribunal to protect a claimant's identity in a case where allegations of serious sexual assault featured, although were not directly being adjudicated upon. Key question that the EAT has to look at is whether the exercise of balancing convention rights has been properly followed by the Tribunal when making the order. Thirdly, we have a case that considers whether an employee can be injuncted for making disparaging or derogatory statements about a former employer after that employee had entered into a settlement agreement expressly stating he'd not make such comments. Finally, as a reward, if you stick with me to the end, I've got news about a podcast interview that I did recently for another podcast series where I was being interviewed. Following on from that, a recommendation in relation to a particularly good podcast series that I've come across, which has nothing to do with law. Anyway, let's do business first. For the first case, Adeshina and St George's Hospitals, NHS Foundation Trust and others. This is an EAT case. It considers whether procedural flaws in the disciplinary process and a failure to comply with the ACAS code rendered the employee's dismissal unfair. Ms Adeshina, whose background is that she's a British national of Nigerian origin and black African ethnicity, worked for the Trust as a pharmacist. She was part of the senior management team when allegations of misconduct were raised against her for allegedly hostile behaviour and alleged lack of cooperation. Her behaviour was investigated and she was referred for a disciplinary hearing, following which she was dismissed for gross misconduct. Ms Adeshina appealed against the dismissal. She argued there were a number of flaws with the disciplinary process, and this included that the decision-maker had taken into account other conduct issues which had not been put to her. The appeal was a full rehearing of the matter and was conducted by two senior directors and a more junior employee. One of the directors had been involved in a document that formed part of the case against Ms Adeshina. The other was a mentor to one of the victims of the alleged misconduct. The more junior member of the team on the panel was a direct report of the manager who conducted the disciplinary hearing. The panel did not take into account the additional conduct issues which Ms Adeshina had not had put to her previously. They discounted that material, but the panel ultimately concluded that it should uphold the decision to dismiss. Ms Adeshina then brought a claim for unfair dismissal and race discrimination. Her claims were dismissed. The Employment Tribunal held that although the initial disciplinary process was unfair, because matters weren't put to her, the appeal panel had carried out a fair process. The conclusion reached by the appeal panel fell within the band of reasonable responses. Therefore, the fair appeal process had the effect of curing the deficiencies at the initial dismissal stage, according to the Employment Tribunal. On that basis, her claim for unfair dismissal and race discrimination failed. Well, Ms Adeshina appealed to the AT, and her main grounds of appeal were, first, the initial decision was so procedurally flawed that it could not be remedied by the appeal panel. Secondly, the appeal panel itself was flawed. It included an employee who was not impartial, because they'd had an involvement in a policy document which was relevant to the disciplinary hearing, and there was also the mentor of one of the people who was involved as the alleged victim. That person's mentor was also one of the decision-making people on the appeal panel. And, of course, it was accepted, as it had to be because it was a matter of fact, that the third employee on the appeal panel was junior to the initial decision-maker. So putting all this together, Ms Adeshina said, well, clearly the appeal is flawed. The appeal panel itself is flawed. And thirdly, she said that she'd clearly been treated so unfairly that ought to raise an inference of race discrimination. Just by way of background, the relevant ACAS guidance on appeal procedure states that employers should, quote, wherever possible, provide for the appeal to be heard by someone senior in authority to the person who took the disciplinary decision, and if possible, someone who is not involved in the original meeting or decision. Pausing there, quick anecdote by sidebar. Some years ago, my wife and I had to employ a nanny. And I can't tell you the hours of endless fun we had trying to work out whether I was going to be the decision maker and she was going to hear any appeals, or whether my wife was the decision maker and I would hear any appeals. Oh, what joy. Anyway, back to this case. The EAT dismissed her appeal. In relation to the first point, the EAT found the flaws in the initial disciplinary process could be remedied at the appeal stage. It was accepted as a matter of principle. The more serious the flaws at that stage, the greater the level of scrutiny required by the appeal panel. However, in the facts of this case, the Employment Tribunal was satisfied that an adequate level of scrutiny had been adopted by the appeal panel. The EAT said this was a decision it was entitled to come to. Secondly, the EAT held it would not always be practical to have a completely impartial appeal panel. It was not necessary to show that none of the members of the appeal panel had had any prior dealings with the individual concerned. In a very helpful passage, the EAT, relying on the industrial experience of the EAT's lay members, stated that individuals, such as the senior manager in question, who was alleged to not have been impartial, quote, will mentor and have involvement in the management of a number of employees, and may well also sit on disciplinary and appeal panels in which those employees might be involved, unquote. The informed observer would, quote, understand that to require an employer to avoid any such link will be both unrealistic and undesirable. Employers are entitled to utilise the knowledge and experience of relevant members of the senior management team in this way. It does not, without more, render the process unfair. Unquote. Pausing there, I think this clear statement of the industrial realities of the situation is to be applauded, because it avoids a technical approach to the composition of internal disciplinary appeals, which would be wholly contrary to common sense. Turning to the issue of the employee who was on the appeal panel, but who was more junior than the alleged decision-maker, the EAT accepted the advice in the ACAS guidance that the person hearing the appeal should be senior than the original decision-maker, but it held there may be circumstances where this was not essential. For example, here, the junior employee was part of a 3-person panel hearing the appeal. He was not acting on his own, and the other 2 members of the panel were senior to the initial decision-maker. Overall, the EAT held it was more important to consider the composition of the panel in the round in deciding whether the overall process was fair and reasonable. In this case, the appeal panel had looked at the facts in detail, had acted fairly and with impartiality. Finally, in relation to the claim for race discrimination, the EAT agreed with the Tribunal. This was a case where, although the initial disciplinary procedure was flawed, the unfairness was not connected to Ms. Adeshina's race. The initial decision-maker genuinely believed that Ms. Adeshina had acted with misconduct and that she was not informed consciously or unconsciously by Ms. Adeshina's race. I think the case is an interesting one. It highlights the importance of the appeal process. Whilst it's undoubtedly important to try and get the initial disciplinary procedure right from the start, it's also useful to remember that it is possible to remedy initial deficiencies by operating a comprehensive and fair appeal process. I should point out that in this case the appeal panel conducted a full rehearing and did it on a very thorough basis, so it's possible that anything less would not have satisfied the Tribunal that the initial deficiencies had been remedied. However, it's useful to know that even where there have been flaws, it is still within the employer's control to ensure that a fair disciplinary appeal conducted by way of a rehearing may cure matters. The decision, I think, is really quite helpful for small and medium-sized employers, because they may also struggle to organise an appeal panel with no prior dealings or knowledge of the disciplinary issue at hand. I think the EAT is sensible to recognise it's not always practical or desirable to make an employer find such a panel. In essence, I think the case is an example of tribunals generally following the principles set out in the Code without needing to follow them to the letter. One additional point which I think is worth mentioning: Ms. Adeshina was legally represented during the appeal stage of the disciplinary procedure, and some of the arguments that she was making to the AT she did not make to the disciplinary panel or the appeal panel, and the Tribunal placed significant emphasis on this fact because she was legally represented. I think as a result it does show that if you are admitting lawyers into internal disciplinary proceedings, maybe willingly or otherwise, there is a downside for the employee in that they will be expected to raise the arguments that they could have raised at that stage because they're legally represented. Clearly, we're some way off encouraging employers to have lawyers in all internal disciplinary and grievance hearings. So, if you're involved in an appeal hearing or advising an employer on the conduct of an appeal hearing, you become aware of flaws in the original disciplinary issue, don't despair. In reality, most flaws are capable of being rectified, and the issue is often whether to admit the flaw and deal with it expressly, or try and deal with it more subtly in the hope that the employee never picks up on the point. Also, we've had to do this on a couple of occasions, some flaws are so serious that the best thing to do is to scrap the entire process, go back to the very first stage and start again with a different disciplining manager. So, that's the case of Adeshina and St George's Hospitals NHS Foundation Trust and others. Next up, a case involving the BBC. It's the British Broadcasting Corporation and Roden. This is an EAT case which is considering a permanent anonymity order made by the Employment Tribunal. The order was made to protect a claimant's identity where allegations of serious sexual assault that had been made against him were disclosed during the course of the tribunal hearing. I should say at the start, we're talking here about an anonymity order after a decision has been concluded by the tribunal. We're not talking about anonymity orders during the running of the hearing. At any stage of a tribunal hearing, the employment judge can elect to restrict public disclosure if it considers it's necessary to protect a person's rights or deems such an order to be in the interests of justice. In deciding whether to make such an order under the tribunal rules, the employment judge is required to undertake a balancing exercise. This considers the principle of open justice and the right to freedom of expression under the European Convention against an individual's right to private life. In this case, Mr. Roden worked for the BBC as a development producer. The BBC was informed by a third party that allegations of an apparently serious sexual nature had been made against him. The BBC passed this information to the police, who in turn told the BBC of a separate incident and that Mr. Roden posed a risk to young men. The BBC subsequently dismissed Mr. Roden. The allegations were only raised with him by the BBC in a broad fashion, as apparently full information had not been provided to the BBC by the police. Later transpired that Mr. Roden had also been dismissed from his previous employment for gross misconduct following similar allegations. When asked during the disciplinary investigation whether similar allegations had previously been raised against him, Mr. Roden failed to disclose this fact. Following his dismissal, Mr. Roden brought a claim of unfair dismissal, amongst others, in the tribunal. The claims were dismissed, but the decision was delivered on an anonymised basis. Permanent anonymity was also ordered by the tribunal to apply even after judgment had been given, and it was on the basis that it could be very difficult for an individual to shake off sexual offence allegations once they'd been made public. And the tribunal noted that public reactions to allegations of sexual offences can be particularly virulent. Following the Employment Tribunal's decision, the BBC notified Mr. Roden and the tribunal of its intention to inform interested parties of Mr. Roden's identity and to provide them with a copy of the tribunal's decision. The BBC's reasons for this were that it wished to discharge its responsibility to those with a proper interest in the content of the judgment, and Mr. Roden objected to this, stating that the proposal was maliciously done in order to unlawfully victimise. In light of this dispute, a further tribunal hearing was convened in respect of the permanent anonymity order. In this hearing, the Employment Tribunal refused the application to set aside the permanent anonymity order and concluded there would be a risk that the public would believe that Mr. Roden had actually committed the offences when they had not even been the subject of any trial. Well, the BBC appealed to the EAT, and the EAT were not really asked to reconsider the legal principles that applied to privacy restrictions, but their application to the facts of this case. BBC's appeal argued the tribunal had made an error of law in its application of the legal principles when conducting the balancing exercise between right to private life versus the principle of open justice. The BBC contended that the anonymity order made by the tribunal was a disproportionate and unlawful interference with those competing rights. In essence, the tribunal and the EAT are grappling here with the intersection between three separate convention rights. Article 6, which is the right to a fair hearing in public, Article 8, which is a qualified right to respect for private and family life, and Article 10, which again is a qualified right, and that's the right to freedom of expression. Well, the BBC's appeal was upheld by the EAT, and in coming to its decision, it considered an earlier case of A and the British Broadcasting Corporation and the justifications for derogating from the principles of open justice. The EAT acknowledged that when anonymity orders are made, convention rights are engaged and must be reconciled. However, it said, a derogation from the common law principle of open justice could only be justified when strictly necessary to secure the proper administration of justice. Here, of course, Mr. Roden made the point that the underlying allegations of inappropriate behaviour towards young men were not going to be determined by the Employment Tribunal hearing. As such, there was a danger that having lost his unfair dismissal claim, the public would assume that he was guilty of the criminal offences, which, of course, does not follow in the slightest. The EAT, however, held that this was not enough to justify derogating from the principle that justice should be done in public. In the EAT's view, whilst the identification of those individuals might be controversial, the public can be trusted to distinguish between an allegation and a finding of guilt. The EAT also concluded there is public interest in naming such individuals so that other potential victims may come forward. Although the Tribunal had identified the need to carry out a balancing exercise and had confirmed that the exercise may vary following judgment, it was not clear that such an exercise had actually been followed by the Employment Tribunal itself. Instead, it seemed to the EAT that the Employment Tribunal's sole reason for making the anonymity order was due to the risk of public misunderstanding and concerns the effect of such a misunderstanding on Mr. Roden. The EAT held that the public interest in open justice outweighs the Article 8 rights of a person suspected of those serious criminal offences. A public judgment could, and did in fact, make clear that the allegations had not been proven against Mr. Roden. Indeed, the judgment made clear that he denied them. He had not yet been afforded any opportunity to contest them, not least in the tribunal proceedings themselves. In addition, the EAT concluded that the arguments against anonymity strengthened after the tribunal's judgment was given. This was because there were a number of relevant bodies and individuals with a strong interest in knowing the outcome of the proceedings. They considered that anonymity for Mr. Roden would constitute a, quote, disproportionate and unlawful interference with the paramount principle of open justice and the strong public interest in full publication, unquote. Consequently, the EAT concluded there was no rational basis for the anonymity order, and the BBC's appeal was allowed. Well, in my view, this case demonstrates a continuing movement by the courts away from granting anonymity on the basis of the consequences that would flow from unproven allegations. It's clear from the judgment the primary concern ought not to be whether the information will become the subject of public knowledge. The case shows a reluctance on the part of the courts to overturn the principle of open justice, despite issues of a sensitive nature being made public. Judgment also demonstrates the need for a tribunal to consider carefully the balancing exercise when making such orders. I would emphasise, however, that the case concerned a permanent anonymity order. During the hearing, there was a restricted reporting order, so that Mr. Roden's anonymity was protected during the tribunal process itself. And it's accepted in the EAT's judgment that a stricter test was required to justify a permanent anonymity order than a restricted reporting order during the hearing. Here, given that one of the planks of the argument for discharging a permanent anonymity order was that the tribunal decision made it clear that the individual allegations of inappropriate predatory behaviour had not been adjudicated by the tribunal, it's clear, I think, from that it would be easier to obtain a restricted reporting order when you haven't got the benefit of that clear-cut statement in the decision. Employers should consider this emphasis by the courts on open justice in relation to any material made public in the claim form or in its defence or during the case. This case demonstrates that even where matters are of a very sensitive nature, they may well be properly publicised outside of the tribunal room, and it seems unlikely the courts are going to permit many restrictions on the basis of reputational rights alone when considering whether to make a permanent anonymity order. I think employers need to assume that any information presented to the tribunal by either the employer or the claimant will make its way into the public domain. Perhaps rather idealistically, the EAT here concluded that the public is capable of separating out allegations from proven charges, but undeniably that approach is in line with the thrust of the senior cases, some of them not employment cases, dealing with these matters. So, to this extent, this case provides clear direction on the principles and tests applicable to permanent anonymity orders, and is definitely good guidance and important reading if you've got a case coming up where you're worried about sensitive material coming to light. So that's the British Broadcasting Corporation and Roden case. So the third and final one I want to talk about was RSM International and Harrison. Very short report on this one. This is a High Court decision considering whether to grant an injunction prohibiting a former employee from making disparaging and derogatory comments about the company. The background is that Mr. Harrison, who was an employee at RSM International, raised a grievance that resulted in aggressive communications by him to the CEO and other employees. Consequently, Mr. Harrison was subjected to a disciplinary hearing that resulted in the termination of his employment through a negotiated settlement agreement with RSM. The settlement agreement provided, as is quite common, that neither Mr. Harrison nor RSM would communicate or publish disparaging or derogatory statements about one another. And that extended to comments made in relation to the settlement agreement and the grievance. In addition, the settlement requirement required Mr. Harrison not to disclose confidential matters, save for circumstances where he was required to do so by law or regulation. Settlement agreement also expressly provided for RSM to seek an injunction if Mr. Harrison made any disparaging or derogatory comments or failed to observe the confidentiality provisions in the agreement. Naturally, Mr. Harrison received independent legal advice before signing the agreement, and he got a severance package as well. Following his departure, Mr. Harrison apparently made numerous complaints against RSM. In these complaints, he stated that RSM International had attacked his professional standing and career during his employment. He also claimed that since his departure, RSM International had attempted to sabotage his search for new employment. He alleged he'd been receiving anonymous phone calls and that RSM had also created IT problems for him. Mr. Harrison continued to contact RSM International by email, making various allegations against them. RSM International asked him to desist, but Mr. Harrison refused to do so. As a result, RSM issued a claim in the High Court for prohibitory injunctions, and Mr. Harrison, not to be outdone, issued a counterclaim asserting that RSM had breached the settlement agreement by, amongst other things, interfering with his online professional profile. Mr. Harrison contended that a grant of injunctions by the court in these circumstances against him would be unwarranted and unnecessary. Well, the High Court disagreed, granting the injunctions in favour of RSM International. It concluded that Mr. Harrison was quite clearly in breach of the settlement agreement, given that he had sent RSM an email only the day before the hearing, in fairly strong terms, and the High Court decided that he would continue to do this unless prevented. The emails being sent by him, alleging dishonesty and malpractice, as well as corrupt behaviour and negative interference with his IT and career development, were deemed to amount to communications and publications. Therefore, he was making adverse comments and publications. The court held that the comments were untrue, they were disparaging and derogatory statements, and therefore Mr. Harrison was acting in breach of the settlement agreement by sending them. In addition, Mr. Harrison had already been asked by RSM to stop contacting it for any reason, so the High Court therefore felt that the application for an injunction was not made without warning. RSM was left with no choice but to injunct Mr. Harrison and prevent him from continuing to make such statements about the company. Well, I think this is a really helpful case. It's reassuring, it's useful to know that there is authority out there for employees to be injuncted if they make disparaging or derogatory statements about their former employer in breach of the settlement agreement. Interestingly, the High Court ordered summary judgment in this case. Their reasons were that Mr. Harrison had no realistic prospect of defending the claim. They considered that with his counterclaim, he had not really identified any real basis for a finding against RSM International in respect of their obligations under the settlement agreement. Therefore, the court decided summary judgment was the appropriate remedy to award here in favour of RSM, and they did so. It would seem, from the summary report of the decision which we have seen, that the facts in this case are fairly extreme. Also, in many cases, an employer needs to decide whether it is better to challenge the ex-employee, who is behaving badly, or to turn the other cheek. The danger is, if you start responding to the ex-employee, it often goads them into making further derogatory or disparaging comments. Certainly discussions we've had with employers in similar circumstances, the inclination has often been to let matters rest in the hope that the ex-employee gets bored and wanders off and challenges other targets. Equally, however, one can certainly understand why RSM, on the apparent facts of this case, felt that was not the right course of action. So that's the three cases, and that last case, that's RSM International and Harrison. Thank you for listening. I said I would make a couple of comments about podcast matters. Actually, before I do, don't forget to spread the word about this podcast. Please do recommend it to friends, family members, clients, etc. It's available via iTunes, Mayor Brown's website, Twitter, under my handle Nicholas Robertson at Nicholas ROBER11. It's on YouTube as well. We were very grateful. So, podcasts. I ended up, out of the blue, being approached to be a guest on a podcast series about where I was interviewed about using podcasts for business development purposes. And I thoroughly enjoyed myself. It was nice being on the receiving end of questions rather than asking the questions. So if you're interested in any way, do check out the series. It looks a really good series generally, some interesting guests on it. But it's Podcast Power Marketing, all one word, Podcast Power Marketing. If you look that up online, that'll bring you up to the right podcast run by a chap Simon Dunant, Dunant. And it was an interesting discussion, and I learned as well as answered questions. And on the subject of podcasts, I would end with a plug for a music podcast. For about a year, 18 months now, I've been listening to a music podcast called The Miller Tells Her Tale by a woman, Karen Miller, hence the title. Do check it out. It's a really good podcast. Lots and lots of new music, stuff I'd never have heard of otherwise, and a brilliant exemplification of, I think it's Billy Bragg's line, that Americana music, which is what this podcast has, Americana music is country music for people who like the Smiths. And on that note, terrible pun, thank you very much indeed, and to the next podcast. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.